All right. Well, look, welcome everyone. I'd just like to start by acknowledging that I'm dialing in from the banks of the Swan River here in Perth on Whadjuk Noongar land, and just acknowledge that the Whadjuk Noongar remain the spiritual and cultural custodians of their land and continue to practice their values, languages, beliefs, and knowledges. Just invite each of you to reflect on the traditional owners of the lands that you're dialing in from as well. So we've got a wonderful lineup. Somehow I managed to join that wonderful lineup. So my name's Ian Murray. I'm the chair of the Charity Law Association, and I've got an interest in près. So I'll be talking on a près case today, and I'm based at the University of WA Law School. But we also have Murray Baird, who is the inaugural Assistant Commissioner General Counsel at the Australian Charities and Not-for-Profits Commission from when it started until 2019. And then Emeritus Professor Myles McGregor-Lowndes, who was the founding director of the Australian Centre for Philanthropy and Non-Profit Studies and co-author of the ACPNS case notes. And you'll see when I get to my case, I duly printed out my ACPNS case note first and read that and realised that I had learned commentary from both Myles and Murray to help me in understanding what had gone on in the case. And Myles has very helpfully put on our first slide a link so that you can access those ACPNS cases. And I think at some point Myles is going to pop up in the chat just a link to the quarterly summary. So as everyone knows, they are a wonderful resource, and it's not just a summary of the facts of the case, but there's a lot of insight as to why the decision happened that way and how it sort of fits in with the broader range of decisions and charity law out there. So in terms of format, the proposal is Murray's going to talk to you first on one of the cases from the first quarter of this year, Grain Technology. And then I'm going to talk on a près case, and then Myles is going to talk on a few further volunteer cases, and then we'll pause for questions after that. So if you have questions at that point, just use the raise hand function or post it in the chat, and we can come to your questions. We have selected, obviously, not all of the cases, but just some of the key ones that we thought fit together rather than trying to cover everything. Murray, I'm going to hand over to you to talk to us about your favourite case, Grain Tech.
Thanks very much, Ian. And Ian, thanks very much for looking after the slides. And I echo your acknowledgement of country. And I joined the meeting from Wurundjeri lands around Melbourne. So let me explain the and we go to the next slide. If you were reading the financial review on the 10th of November 2011, the headline was this: easy going from non-profit to 50 million. The transition from grant researcher to property developer is not a common one, but for three directors of an obscure industry organisation, NRI Australia, it's been a lucrative switch. In February, without even needing to consult a law firm, the trio turned a not-for-profit organisation holding 50 million of assets into a private company that they controlled. So the intrigue commences right back in 2011. We had a court result in 2023, thus slowly grind the wheels of the law. Go to the next slide, which will show us firstly what was able to be done with that site at 1 Rivet Road, North Ryde, a vehicle building leased to 3M, which had been intended to be research for a cheaper bread in Australia. That turned out to be quite a lucrative property investment for the three directors who took over this otherwise not-for-profit company.
So Murray, can I just ask you to pause for one moment, because there's a little bit of interference. Can I just ask everyone to put their mics on mute if they can, please? Sorry, Murray, back over to you.
That's fine. So this is a 50 million from a not-for-profit purpose to a private purpose, 65 million the Constitution. And all parties, including the Attorney General of New South Wales, come to court with agreements that the nature of this charitable corporation and the need to apply the assets to charitable purposes. But the court says this is neither a charitable corporation nor involved a charitable trust. And so the application was misconceived and the parties were sent away. The matter was unresolved and the appeal was withdrawn. So the case rests where it was decided. Go to the next slide.
Now, Murray, we're still getting a little bit of interference. Have you got a different, it was working perfectly well before when you tested it. Have you got a different speaker you can try? Sorry, I think I've caused trouble because I've muted everyone and then asked Murray to unmute in the hope that that will also deal with things. Just give Murray a moment to dial out and in.
And the video.
Oh, there we are. Oh, hang on. Right, we can hear you beautifully now, Murray.
And I trust you can see me, but perhaps not as beautifully. Is that clearer?
It is.
Ah, good. A colleague of mine was at part of the seminar, and she was able to give me a set of earphones. So just to give you some context, the Rosewood is the new name for the Baird Research Institute. Grain Tech was a consortium of concerned bystanders with an interest in the bread industry and a concern for the diversion of the assets. Baird Research Institute was founded in 1948. It was a CLG. It later became a corporate association, then back to a CLG. And its objects focused on improving the bread making through research, education, and information. The Constitution had the usual not-for-profit clause, a distribution to bread manufacturers in the event of winding up, and it had an independency of objects clause, which was not unusual in those days, to say that each object can be read independently. And in due course, the company had some subsidiaries, real estate, research, and intellectual property subsidiaries. So you get the idea of this research institute. We'll go to the next slide. Why is this case notable? How does it get into this seminar? Well, the preferred vehicle for doing charity in Australia appears now to be the charitable corporation. And in fact, many government departments and funders are requiring an entity to become a corporation to be eligible for funding. So, and certainly the concept of charity for Commonwealth purposes is structure agnostic, and you'll see from 2055 of the ACNC Act that a body corporate can be included in the rubric of charity. So the question is the charitable corporation a species of charitable trust? That is, does a charitable corporation hold its funds as a trustee? And if not, is it a quasi-charitable trust and subject to similar constraints? That is it pretty similar to? And can a charitable corporation simply change its objects by resolution rather than by près orders? But the real reason I think that this case finds itself as a notable case is the facts, to me, offend the notion of fairness. So we'll go to the next slide. Here's what the judge said generally about the concept of the charitable corporation. So far as the parties' arguments went, and my further research has gone, there is no Australian case which considers directly and as part of its ratio whether property held by a company having charitable objects is held by the company as a trustee, in the strict sense for purposes expressed in those objects. So the court is saying, I can't find any authority in Australia which would give us some guidance as to whether a company is in fact governed by trust principles in these circumstances. We'll go to the next slide. But there is a history of worrying about this problem. For example, in Scott and Ash's book in 2008, the truth is that in some senses, a charitable corporation is a trustee, and in other senses, it's not. The question in each case is whether a rule that applies to trustees also applies to the charitable corporation. And then Australia's own Professor Ford said this: perhaps it's better to call it a quasi-trust. It's not a true trust because the management of a charitable corporation's property is governed by the law of corporations rather than the law of trusts. But it's similar to a charitable trust in that the Attorney General can enforce devotion of the corporation's funds to the corporation's charitable purposes. And in consequence, it is conceived that charitable corporation does not take beneficially, which suggests the trust rubric. We'll go to the next slide. We see a line of authorities, this one from Hong Kong, and then I'll go to the Supreme Court in the UK, which certainly lead us in the direction that the idea of the charitable corporation is a different type of corporation to the commercial corporation or the for-profit corporation. So this is the China Chem case, where the Lord Walker of Gestingthorpe says this: human beneficial owners of property, if of full age and sound mind, can dispose of their property as they like. But a charitable corporation may use its resources only for its charitable objects. So in practical terms, it is not very different from a charitable trust, especially as the law imposes on individuals who manage the corporation's affairs the same fiduciary obligations in relating to deriving personal profit from their office and similar matters as are imposed on the trustees. So we're seeing that move to, well, it may not be a straight charitable trust, but it's a quasi-charitable trust. Let's go to Letamarki's case, which was a significant direction in the idea that directors and even members of a charitable company have fiduciary duties. There had been little or no litigation about charitable companies registered under the Companies Act in this regard before, namely the court's determination to make the statutory framework cohesive where this could be achieved. It is recognised that registered companies could be charities, and that meant that the new charitable vehicle had to meet both the charitable and the corporate model. So we see this idea of the convergence of the jurisprudence of the company with the jurisprudence of charitable trusts. And how do we reconcile them? Because in fact, they are brought together in the majority of new charities formed in Australia. Let's see what the judge said about this in Grain Tech. I think that an absolute rule that gifts to corporations having charitable objects are held on trust is not consistent with principle. The same applies to the contention that a corporation having wholly charitable objects necessarily holds its property as trustee for charitable purposes. Charitable trusts and charitable corporations are, quite simply, different types of legal institution. And so here in Grain Tech, we eschew the idea of convergence. So what were the findings? BRI is neither a charitable corporation, nor holds assets on a charitable trust, nor attracts a quasi-trust jurisdiction. Its objects must be read independently. Research alone without dissemination or education is not charitable. Promotion of the bread industry is too narrow to be for the public benefit. Promotion of the industry may go beyond education and sharing research. It could extend to propaganda. Cheaper, better bread may benefit the public, but it is not within the charity rubric of pencil categories such as relief of poverty. And so we take into account that the parties came to court all agreed that this was a charitable trust matter and that charitable trust principles should apply. The only differences was the scope of that charitable trust. But what the judge said is, no, that's misconceived. Go away and sort it out by some other method. because I'm not prepared to find a charitable trust. So it's interesting to see what happened next. The parties had indeed settled this case subject to some matters to be sorted out by the court, and that was the application for the declaration. And we read about that in Grain Technology number 4. The judge dismisses the application to enforce the settlement agreement and confirms that the plaintiff's undertaking as to damages and confirms the plaintiff's undertaking as to damages in the event of an adverse result. Interesting that a judge should, in a later case, say, and by the way, you are still subject to the undertaking as to damages and the jeopardy of costs. And I wonder whether that was a warning to the plaintiff that as officious bystanders, if they pressed on, it was with some jeopardy. So the plaintiffs lodged an appeal against the decision, but later withdrew the appeal in exchange for a release from damages undertakings and costs orders against them. And that appears in case number 5. But it was very interesting that McGrath, Justice McGrath in case number 5 says, the plaintiff's appeal is seriously arguable. So we find the state of the law in an unhappy situation. Another judge of the court says, oh, this had a seriously arguable appeal point, but the parties decided not to take it on. I presume the officious bystanders simply thought this is hard work. So we go to the next slide. I'll make some final comments. The law in New South Wales is still uncertain on a key issue of charitable law and practice, and arguably inconsistent with the weight of authority in other jurisdictions. The decision is at odds with the approach of the High Court in Commissioner of Taxation v. Word Investments on issues of the way you deal with independency objects, the way you deal with the approach to discerning charitable intent by way of a holistic approach. And also, it's inconsistent, it seems to me, with that probable result test which the High Court put. It's also inconsistent with a number of cases referred to by the case authors in the QUT case note series, which I'll allow you to read yourself. And some would suggest that it's the conduct of the profiting directors and members appears to be inconsistent with the rule in Barnes and Addy. Now, Barnes and Addy disappeared from jurisprudence for almost a century. It's reappeared in this context. What it was really about was whether a third party can take advantage of the assets in a charitable trust and be held accountable for that as a breach of trust. And it seems to me that in this case, Barnes and Addy could be arguable, that the members and directors who ended up with the 50 million plus in their own pocket may have been said to have taken advantage of assets that were otherwise intended in a trust context. So the issue remains uncertain. It was deftly sidestepped in a later Victorian case of Housing Choices Australia Ltd, which was a près in relation to a charitable corporation. And so we are left in some uncertainty with the tantalising possibility that another case will come along where we will get further guidance and perhaps fall into step with like jurisdictions. Thanks, Ian.
Thank you, Murray. And what a wonderful lead-in to the next case that we're going to talk about, which is Housing Choices, the case where the court sidestepped having to determine whether assets would be held on charitable trust by a charitable corporation. So I'll talk about this case. It was a près case, so an application to reform the charitable purposes of a charitable trust. And I've put up on this slide what the old purposes were and what the proposed new purposes were. So you can see it was a charitable trust established over 16 dwellings, 16 houses in around 1960. And the original purposes, you can see, is reasonably narrow, if a little bit unclear. So using the dwellings for aged, deserving or infirm persons who are inhabitants of Geelong in Victoria. And then you can see also subject to the rules, regulations, etc., passed by the committee for the time being of the Geelong and Western Districts Ladies Benevolent Association. So providing housing for age deserving or infirm persons, whatever that phrase means, given the lack of commas there. The proposed new purpose is far, far broader. So providing affordable housing and related support to people in Victoria who are disadvantaged in different ways, but not limited to being age deserving or infirm persons. So you can see a range of different factors listed there, which were based on Victorian government priorities about who should be given social housing. So in terms of what happened, so you can see the Ladies Benevolent Association, which was meant to be forming rules and regulations for the operation of the trust, became defunct sometime around 2001 to 2003 and appointed a replacement trustee. The replacement trustee administered the trust for about a decade or so, and then there was a housing inspection which indicated a number of deficiencies that needed rectifying, and the trustee decided it was too difficult to rectify all those deficiencies under the terms of the existing charitable trust. So there was a memorandum of understanding with a new potential trustee, Housing Choices, so the party in the case, and the MOU provided for Housing Choices to become the new trustee and to redevelop the housing so as to meet that, or rectify the deficiencies identified in that housing inspection, but also improve the housing stock so it was sort of also more accessible for people. But to obtain Victorian government funding, Housing Choices had to agree to a drastic broadening of who could actually access that social housing. You saw the purpose on the previous slide, aimed at people with a range of different disadvantages, which was in line with the social housing priorities of the Victorian government. So they had to agree to broaden who could access that housing. So Housing Choices applied for a CPRE scheme under Section 2 of the Charities Act 1978 Victoria. You don't need to go off and read Section 2 at the moment, because on the next slide, we look at what some of those grounds or occasions for obtaining a CPRE scheme actually are. Interestingly, the Attorney General didn't oppose, appear, or make any submissions. So even though the Attorney General is meant to be the protector of charities and protect the charitable purposes and their continued fulfilment, the Attorney General had no role at all in this case. So in terms of what was the decision, well, I guess there's sort of two steps or two sort of substantive steps in applying for a CPRE scheme. One, you've got to convince the court that you've actually got an occasional ground to get a CPRE scheme, whatever that scheme is in the first place, and we'll look at that. And then the next step, which we'll look at on the next slide, is, well, once you've convinced the court that you're entitled to or can have a CPRE scheme, then the court has to be happy to approve the actual scheme that you're proposing. So one, can you get a CPRE scheme? And then two, will the particular scheme you've proposed actually be approved? So we're sort of looking at the first bit of that here, the question about was Housing Choices entitled to even obtain a CPRE scheme in the first place? You can see I've made a comment there, perhaps not entirely favourable. This is a pretty complex area. The provisions aren't used that often. The reasoning in the case as to whether the grounds or occasion for a CPRE scheme were made out 2 paragraphs, 200 words. So not extensive consideration. This was sort of a box. Well, that's perhaps a little unfair, but the parties' submissions were accepted without a lot of investigation being made, at least on the face of the decision itself, which is not uncommon, I have to say, in many CPRE cases, and we will return to this at the end. The question of whether we actually need to go to court and use up court time and resources to make these decisions. Anyway, returning to Housing Choices, one of the grounds that was suggested was Section 21A2, so where the original purposes in whole or in part cannot be carried out. And one of the arguments was, well, we can't carry out the original purposes because the Ladies Benevolent Association, which is meant to form rules and regulations for the administration of the trust, has now become defunct. So they can't issue those rules and regulations. And also because the phrase age deserving or infirm is ambiguous, so we can't, we don't know what the purpose is that we're meant to be pursuing. I suppose my query on that, which was not considered, at least on the reasons in the judgment, is one, normally you'd be thinking an administrative scheme for a mere change of trustee or change of administrative arrangements, like the issuing of regulations for the carrying out of the purpose, rather than necessarily a près scheme. So I just wonder whether an administrative scheme would be the right response to that lack of ability to create rules and regulations by the Ladies Benevolent Association, and certainly that would be more in keeping with some of the other case law. Also, if the phrase age deserving or infirm is ambiguous, then normally that's a question of construction, and you'd expect the court to try and construe that term. And if it can't be construed in a way, in a meaningful way, so it really is ambiguous and has no meaning, well, then there's a question of, well, was there a general charitable intent? And we'll apply a près scheme on that basis. But there was no discussion of general charitable intent or the court adopting principles of construction to actually construe that term. I mean, there were submissions made about what possible constructions might have been by housing choices, but no decision by the court about how that term should be construed. So anyway, I just raise that to point out that there are a few questions that could have been investigated there to really work out whether that ground 21A2 applied. The second ground that was suggested, 21E3, where the original purposes in whole or in part have ceased to provide a suitable and effective method of using the property, regard being had to the spirit of the gift. And the spirit of the gift is sort of an odd concept. It's sort of meant to be the general intention or broad intention underlying the original gift in the first place. So rather than just the words used in the trust instrument, it's the broader intention, and you can look to the broader context to work out what that overarching intention of the donor was. So you're meant to look to that and work out, well, is this, we've got some difficulties in the use of the property. Is it frustrating that broader intention that the donor had when they made the gift in the first place? And the argument that Housing Choices made was that age deserving or infirm on some of the potential meanings doesn't align with contemporary social and economic conditions where a broader range of demographic groups need housing. And the judge accepted that and pointed to domestic violence as being another reason for needing housing. So that's entirely consistent with other cases that have looked to social and economic circumstances in working out, well, have the original purposes ceased to provide a suitable and effective method? And the other point that the judge looked to is without broadening the recipients, then government funding wouldn't have been available, and therefore it might cause difficulties for redeveloping the property. The judge also suggested that the spirit of the gift was satisfied because the new purposes, which were Housing Choices purposes, closely aligned with the original trust purposes. And I've already expressed some questions about how closely they really were aligned. Sure, they're both aimed at providing housing, but obviously one set of purposes is for a much broader range of recipients than the original set of purposes. And I guess the query that I had here is, again, the discussion was very brief, and it might well be that it would not have been possible to obtain funding to redevelop the housing to satisfy the original purposes, but there was no evidence other than pretty big implications from the evidence that was provided that that was the case. And in cases, the New South Wales Helicopter Service case is referred to in this one. That's a recent another recent decision where there was a bit more evidence provided about how it would not be possible to actually carry out that original purpose anymore because of changed conditions. So it might well be correct that 21E3 should apply here. It's just there wasn't, I guess, the level of discussion that you'd expect to sort of explain why it was that government funding could only be obtained for these broader, pursuing these broader range of purposes, and how you couldn't otherwise get funding, and therefore the property would just be sitting there. So grounds were made out. That then gets us to the next question, which is the particular scheme. So the particular scheme here was Housing Choices would hold the trust property as its general property to apply for its own charitable objects. And those were the ones that I put up on that first slide, that broader set of purposes. Again, we've got 2 paragraphs of reasoning and 183 words. So again, a pretty brief consideration of whether those new purposes were près or sufficiently close to the original purposes, because that's what the court is meant to be looking at when they're considering an alternative scheme. Are the new purposes sufficiently close to the original purposes that we will approve this particular scheme that you've proposed? You can see that what happened is that the court did impose some restrictions. They effectively, the orders made were that they would approve the proposed scheme, but subject to the rider that Housing Choices had to notify the Attorney General of any proposed change to those purposes. Now, I guess one question I had, which I've talked about a little bit already, is, were the new purposes really as close as possible to the original purposes? And it would have been nice to see a little bit more discussion on that. I guess the bigger question is, what does this all mean? Murray has already sort of raised some of these issues about a charitable corporation holding assets for its general purposes and whether it holds on trust. So here we've got a scheme being approved, the scheme being that Housing Choices holds the original assets for its general purposes, and then subject to this requirement to notify the Attorney General of any changes, and also subject to the requirement that because its purposes were broader than Victoria, that these assets were held for use in providing housing in Victoria. So I guess I was wondering, well, does that bring the charitable trust to an end? There was no purported creation of a new trust here, although I'm not sure that was intended. And yet if we have assets being held for charitable purposes with some conditions attached, they're not actually being held for charitable purposes. There are some conditions. And so how do we give effect to those conditions? Does that mean we've created a new charitable trust to give effect to those conditions? Are we just relying on company law and ACNC regulatory requirements to control changes? Because a question that Murray had raised in the case note, the ACPNS case note on this case, is if the AG was notified and didn't like the proposed change to Housing Choices objects, what would the AG do? Would they come and assert a breach of charitable trust? And if not, what role have they got coming to court to complain about any change of the objects? I mean, shouldn't it be ASIC? This, I think, was a company limited by guarantee. So should it not be ASIC coming to court and trying to allege under company law that the purposes couldn't be changed? So anyway, that's why I've got a lot of question marks in this paragraph. I couldn't quite work out legally what the effect of all this would be and whether we were creating a new charitable trust or not. So I'd be quite interested in talking to anyone after who's got a clearer and better idea than I have on that. All right, so that leads me then to thinking, is this a good situation to be in? Or should we think about some reforms that have been carried out that we could perhaps adopt and adapt for our own purposes? And I'm thinking here of reforms in England and Wales that have taken place over a few decades, but most recently took place as a result of the Charities Act 2022 UK, which had provisions commencing in March of this year that would specifically apply to changes of charitable purpose by charitable trusts. Now, the first question I've got is, why make Housing Choices go to the Supreme Court to get this près scheme approved? Now, I completely accept that many jurisdictions around Australia allow the Attorney General to approve changes for small charitable trusts, but those thresholds are usually pretty low. So many charitable trusts would be too big to apply and get Attorney General approval. Typically, you have to go to court. If the courts are engaging in something akin to a box ticking exercise in many of these cases, then I'm not sure there's a lot of value add by forcing parties to go to court. Why don't we just let the Attorney General approve près scheme applications? And then the Attorney General could always decide that there's a particular application for which the court needs to get involved. But as a general course, ought we to force all these parties to go to court? And housing choice, as I said before, is not unusual. This is the usual result, is very brief reasoning, acceptance of parties' arguments that près grounds are made out, and acceptance of the proposed scheme. And that's because courts are trying to help parties make effective use of charitable assets. It doesn't really serve the public any good for assets to be sitting there for years, not being used for any good purpose. And then the second question is, how do we deal with schemes that involve trust property being given to a corporation for its corporate purposes? That starts raising all the sorts of issues that Murray had flagged in his presentation. And so the recent UK reforms are interesting in dealing with both of those issues, in that from March this year, it's become slightly harder for charitable companies to change their objects. So they've always had to get Charity Commission, well, not always, but for many years, they've had to get Charity Commission consent to a change of objects, which is different than the position in Australia. But that consent has been tightened up a little bit now. So it's slightly harder now for charitable corporations in England and Wales to change their objects. And it's become materially easier for trustees of charitable trusts to seek a change of their objects. So you can see there, whenever the trustees in good faith consider it is expedient. So it doesn't have to become inexpedient or cease to provide a suitable and effective method. Whenever the trustees think it's a good idea, because they can more effectively use the trust assets, they can apply for a près scheme. So we've effectively entirely removed the ground stage for près schemes in England and Wales. And then the Charity Commission gives consent, and in giving consent has regard to a range of factors, some of which maintain donor intent and similarity with original purposes, but those factors also include economic and social considerations, so we can take account of change over time. So there's been a real watering down of the ground stage, and then also at that alternative scheme stage, the requirement for absolute similarity to the original purposes. So it's much easier in the UK for charitable trusts to change their objects now. But it's all done in a regulated space where you still have to go and get consent, not from the court, although you can do that, but the option is there for any of these changes to go to the Charity Commission and administrator to approve that change. So there's obviously a real time and cost saving in doing that. Right, I will stop there, Miles, and hand over to you.
Ian, given we've got some time up our sleeves, I wondered if, before we move on to a completely different topic of volunteers, if we don't invite questions to Murray and Ian first up about these matters. My first question was more of a comment, is that leaving this solely to the Attorney General, one of the themes that seem to be running through these cases is that there's government agencies that want broader objects or modifications to these organisations, and the attorney may have a conflict of interest or a possible conflict of interest. So I'm keen for the court still to be involved at an appropriate threshold. But what do you think?
I think that's a valid point. We've seen extreme examples of this in the US where there are real conflicts, very parochial decisions by attorneys general to basically not let funds be spent outside the state that they're the attorney general of. And so I think that's a real issue, obviously completely avoided to some extent in the UK by the fact that it's the Charity Commission, which doesn't have, is not a minister making the decision. So I think that's a real issue. To resolve that here might require a referral of powers by the states. So that's probably a bit of a step too far anytime soon if we try to give it to the ACNC, that role. So I think that's a fair point, Miles. Murray, did you want to comment?
You can hear me clearly?
Yes.
That's good. So often the Attorney General seems to be missing in action. Often they don't put in a submission. And sometimes you might be concerned whether the attorney really is protecting, coming as a protector of charities and trying to maintain the charity. And so the jurisdiction seems somewhat neglected of the Attorney General as protector of charities. So I'd make that observation. And so perhaps there is some need for a statutory revisit of that question.
Thanks, Brian. Andrew Lind, you've got your hand up.
Yeah, thanks, Ian, and thanks, Murray. My question is in the context of mergers and acquisitions and restructures. So let's say we have a bundle of charitable assets clearly held on charitable trust. We'll call that Trust A, and they, for various reasons, decide that those assets are going to move to a new entity that exists for charitable purposes, but they want to move the new entity is a CLG which is not the trustee of a charitable trust. Is it open to the existing trustee to gift those assets, dispose of those charitable trust assets to a company that does not expressly hold those assets on trust? Is that a breach of trust in doing so, based on the law that has come out of Grain Technologies? Or should that existing trustee say, no, I shouldn't be doing that unless the transferee very clearly agrees to hold those assets on charitable trust? Now, I know we've got the presumption that if there's a gift, those assets are held on trust for its purposes. Grain Technology made that clear, so that maybe puts a finger in that hole in the dike, but that doesn't deal with after acquired assets of the transferee. So should there be a requirement as part of that restructure that the transferee also establishes an express charitable trust and takes the assets in that trust?
It seems to me that that is simply a retirement and appointment of a trustee. The charitable corporation, in my view, ought to be a corporation which has solely charitable objects. But that is not to say that any corporation cannot take some funds on trust, but that does not make it a charitable corporation. It makes it a trustee for some purposes. And of course, we have some publicly listed trustee companies that take that role. They're there for the profit of their shareholders, but they hold a series of funds on trust. So I would have thought it depends on what is clearly declared and understood at the time of the transfer, and it ought to be that it's taken on the same trusts as it was previously held.
Thanks, Murray. Anne.
Thanks, Ian. I had a couple of questions, if I could, for both Ian, you and Murray, in relation to Grain Tech. Did the court fail fail our sector in not addressing the question of the contract, the nature of the charitable organisation that's set up as a CLG as having obligations under contract to fulfil the purposes set out in the Constitution, because that seemed to me to be undeveloped in that decision? And secondly, is it time for us to advocate strongly for the charitable corporation like the CIO in Australia? Two questions.
And certainly the emphasis in case number 3 was all about the question of a charitable trust, and there didn't seem to be much consideration about the contract itself. So your argument is there ought to be a contract between the members to hold the assets for certain purposes, and they breach that contract if they put it into their own pocket. I might even be so bold as to throw the question back to you. The case seemed to be taken, certainly in case number 3, on the basis that everyone agreed that there was a charitable trust here, and therefore they didn't get to the contract argument. But would you like to comment on that as having some, I think it was your letter to the Fin Review that started this whole matter off.
Yeah, I think it was a shame that that argument, just the equitable aspects of contract law, I think was a really missed opportunity. And I know there was the whole circuitous and fear of costs situation in that case made it very difficult to engage with that issue. But it seemed to be something that was a fail. It was a shame that that issue wasn't really aired properly. That is that the Constitution is a contract. The members at the time that they agreed amongst themselves to turn it to a proprietary company of which they were the only shareholders, and therefore that's how you steal 50 million in assets, that the time they made that decision that they were actually in breach of the contract.
You may have been faced with the argument that contracting parties, and there were only 3 left, can vary a contract in any way they choose. And that may have been a difficult argument to answer.
Absolutely.
Ian, did you want to comment on that one?
I was, and that is moving beyond contract to think, because it's, we've got company law that can help here, not just contract. So if we're thinking members' remedies, and then also action by the corporate regulator ASIC, I mean, there are just and equitable winding up grounds that would respond to a change of purpose from the original common purpose of the members, which a corporate regulator could take action in relation to. So I think even if the members can agree to permit a change to the contract, I think there are remedies that ASIC or approaches ASIC could use to act where directors have put proposed resolution to members that would then result in a change to a common purpose that had been agreed by the original members. So I think there's a bit of work that could be done there.
And I think so, Ian, and that was the argument, obviously, in Maitanaki, that it was the argument that they were able to rely on the court there was based on the CIO, specifically the provisions in the legislation that applied to that particular corporate entity. And that's why I guess that Dorothy Dixon of the second part of my question is so that would seem to be a way of rescuing this entity, which otherwise doesn't seem to be fit for purpose. Sorry, mate.
Sorry, Anne. In relation to the second part of your question, which I didn't address, it seems to me that the company limited by guarantee is a very flexible vehicle, and that if we simply extend the ideas in Letamaki, we are going to get to the point of a different species of company that has a particular rubric around it. And therefore, we may not need to find a separate vehicle. We simply say we have a charitable corporation. It is a corporation with solely charitable objects, which is registered with the Commonwealth regulator, and we call the charitable corporation, and therefore it is bound by the law of charitable trusts.
And you could also, I mean, to drop the word limited from your name, I mean, that's intended for a subset of companies limited by guarantee that are charitable anyway. We could adopt a UK approach of just saying that you can't amend the objects of a charitable corporation without getting regulator consent. That there could be sort of company law ways of addressing the issue without even expressly imposing a trust if you wanted to. Any other questions that people have? I'm just checking in the chat. No. Miles, I think over to you to talk to us about volunteers.
Thanks very much, Ian. I've just noted in the last couple of quarters 1 or 2 cases before the Fair Work Commission about volunteers, usually self-represented, but not always. And I thought that'd be interesting just to raise with you. They usually involve claims of bullying or unfair dismissal. In claims relating to bullying, the issue is whether the person is a volunteer, usually within the meaning of the Fair Work Act, and that slips you to a definition of volunteer in the Workplace Health and Safety Act. A worker there is defined as a volunteer. In most cases, the volunteer has ended their relationship with the organisation, or the organisation ends the relationship, and the commissioner is reluctant to issue any orders concerning the bullying because it can't happen anymore because the person's not in that relationship. But people seem to be dead set keen to get before the commission, even though they've been advised that that's the case. In relation to unfair dismissal, the claim usually involves whether the person is a volunteer or an employee. And then, as we'll see in another case, in one of the cases, whether the meaning of persons conducting a business or undertaking is applicable to the organisation for which the person is a volunteer or employee. So running quickly through the cases, which I've set up the links in the chat, in the New South Wales Fire and Rescue Band, it was an incorporated association in New South Wales. 2 band members were expelled as members under disciplinary procedures. Instead of going through the civil courts, they made applications to the Fair Work that they had been unfairly dismissed. And the question is, were they employed? Well, their argument was that they were paid $15 an hour for rehearsals, engagements. One was also appointed a librarian and paid an hourly amount for maintaining the library. And the terms of that were contained in a band protocol, which they said was the contract of employment, and they both had signed. So they were pulling about $2,000 to $2,500 a year from the association, plus there were overseas trips where the band went to play. The commission said that the payments were honorariums, not wages. The protocol was not a negotiated agreement. It was just given to them and signed. And there was no tax or super paid, so they weren't employees, and the matter was dismissed. The commissioner did have some strong words to say to the government about the band and its funding, and the lack of attention to these long-standing band members. Quickly going to the next one I want to raise with you is, it's an odd case, Stephen Lake and Wild Walks. Basically, Lake agreed to sub-edit a magazine about bushwalking for Wild Walks. Wild Walks was a web-based bushwalking guide. The 2 people had a verbal agreement that the sub-editing would attract the fee of $1 per year. This is a verbal agreement. It was only ever paid once. But the court recorded that the reason for this was, according to tax advice, Mr. Lake submits that the $1 per year is taxable income from which he can claim tax deductions associated with sub-editing work, including repairs, capital expenditure, and the use of his personal computer. It is expenses such as these that Mr. Lake submits the $1 per year, which represents a pro rata value. Well, he was dismissed from his role, but the odd thing here was he's happy to work as a volunteer on other projects, and the other person was very happy for him to work with him as volunteer on other projects. But for some reason, they took this to the commission. The commission found that despite being paid $1 per year and having tax involved, he was still a volunteer, and this was just an honorarium. And the commissioner noted, and this is where really, I've never seen a case like this before, having read the emails between the parties, it was pleasing to see the respect and joy between the parties. Whilst it is unfortunate that collaboration on the magazine has ended, it is positive to see that the differences have been respectfully set aside for ongoing collaboration on other projects that benefit the community broadly and the parties, albeit for altruistic purposes. Yeah, it's interesting. I think there might have been something else going on there, but I'm not quite sure what. In the next case is Anthony Walsh's case. This involved Mr. Walsh being a volunteer at a community radio station. Both the station and Mr. Walsh agreed that he was in fact a volunteer. He was dismissed as a volunteer, and it was a matter of it was a matter of bullying rather than being dismissed. The question here was whether the station fell within the Act. And the issue here was it conducting a business or undertaking for the purposes of the Workplace Health and Safety Act? The Act says in Section 5, a volunteer association does not conduct a business or undertaking for the purposes of this Act, and it goes on to further explain that in Section 8. The station in evidence did not have employees, but it did engage a lot of people. It engaged them on contract with their own ABNs and paid them for doing secretarial work or online announcing and specialist functions. The Fair Work Commission found that it was not a volunteer association. But I just quickly warn, and there's more in the case note, that legislative changes, which will probably come in at the end of this month, under the Fair Work Legislation Amendment Closing Loopholes No. 2 Act 2024, because of the changed definitions and return to the multifactorial assessment of whether you're an employee or a contractor, may change the result of this case. So, Ian, over to you.
Thank you, Miles. Well, amazingly well done, Miles. Much better than Murray and I in terms of keeping to time and getting all the information across. So, look, a big thanks to Miles and to Murray, and in particular to ACPNS for having these case notes. And we're hopeful that this will be the first in a series of seminars where we get to focus on the cases featured in those ACPNS case notes. So thank you very much. Otherwise, thank you very much, everyone. We'll post the recording of this up on the Charity Law Association website in the course of the next week or so, if you want to come back and listen to any, or if you've got colleagues who'd be interested as well. So thanks, everyone, and have a good day.
Thanks, Ian. Thanks, everyone.